Thank you very much to Concurrence and the distinguished jury for selecting my article, Is Planet Merger Control Becoming Uninhabitable, as the best cross-border business article in 2024. I'm really honored. In this article, I describe a number of recent developments, especially in the merger control context, and some unresolved older problems that make it much harder for M&A transactions to get through the regulatory process, and add to that the global proliferation of FDI and new tools such as the foreign subsidies regulation. That's really the perfect regulatory storm for global transactions. Just a couple of examples. We face more below threshold interventions with the new Article 22 referral policy of the European Commission, the revival of the Tower Cast jurisprudence, which is bringing back continental can from the 1980s, and now a recent focus on other types of transactions such as acqui-hires or minority shareholdings with collaboration arrangements, especially in the AI space, where the regulatory authorities are also considering how to get their hands on these cases. On the substantive side, we've long had a focus on killer acquisitions, especially in the pharma and life sciences industry. That has morphed into theories around digital industries, where I have dubbed these transactions zombie transactions, because the idea is not to kill the target, but really to keep it alive and work with that additional business model. And then we have a recent focus on ecosystem-based theories of harm. If you think about the Booking.com eTraveli transaction that was blocked by the European Commission, this was really about entrenchment and strengthening a pre-existing position through broadening the ecosystem. On the procedural side, we're really still seeing a lack of self-restraint by the agencies. Even in very simple cases, you get hundreds of questions, and in complex cases, things take forever. So we have a number of transactions recently that have just been abandoned because of the regulatory difficulties, because the uncertainty of the time frame, because the parties just reached the long stop date and didn't want to take their chances anymore. That also leads to a situation where these novel theories of harm are no longer tested in court, so they become case law precedent. So what do we do about this? Well, you have to go through the 5 stages of grief and just accept it's a different world and play the cards you're dealt. On the other hand, though, it really requires a different skill set now to think about transformative M&A transactions. You need to think merger control, FDI, FSR, and other things. Bring all of those together, have a holistic strategy, but you need to be flexible. Things are fluid. You need to have fallback plans. You need a GR, a PR strategy, and all of that. At the end of the day, this makes our lives much more interesting.